Hey everyone, welcome back to Norton Rose Fulbright's Texas Business Court Insider, where we're tracking developments in the Texas Business Court and beyond. Today you've got me, Rafe Schaefer, and Kate Ergenbright. We're commercial and energy disputes partners here in Houston, Texas. Don't forget to hit like and subscribe to get notified when we post a new video. Kate, what are we talking about today?
Well, today we're going to be talking about Senate Bill 29, which is a new corporate governance-related bill that has been enacted in Texas and recently signed by the governor. There are several important things about this bill that we're going to be talking about today that are not only relevant to those that litigate corporate governance disputes in Texas, but also for those that work with entities that are either incorporated in Texas or incorporated elsewhere, but want to take advantage of Senate Bill 29's new business-friendly provisions, which include codification of longstanding corporate governance case law, like the business judgment rule, and some very interesting safe harbor provisions that we're going to talk about today.
Yeah, so let's dive right into that first aspect of the bill, the codification of the business judgment rule in Texas. For those who are watching this video, you probably already know what the business judgment rule is, but if you don't, it's the presumption that directors and officers of a corporation act on an informed basis, in good faith, and with the honest belief that their action is taken in the best interest of a company when making a business decision. That rule originated as a common law principle in Delaware and has quickly spread across the United States. So Kate, what is it about Senate Bill 29 that makes the business judgment rule in Texas so unique?
Well, it's the fact that it's now codified. As you mentioned, this is not a new concept to Texas. There is a body of case law that is developed, but that case law develops piece by piece and based on the particular factual scenarios at issue in those individual cases. Now that the business judgment rule is codified, there is clarity and comfort for both limited liability companies, limited partnerships, and corporations that the business judgment rule applies. Interestingly, it's not just companies that or any of those forms of entities that are incorporated in Texas or formed under Texas law. If you have an entity that is, for example, formed under Idaho law, they can decide and include in their governing documents that they want to be subject to Senate Bill 29 and these business-friendly presumptions like the business judgment rule.
Let me just pick up on that because I agree with you. That is very interesting, Kate. I think it goes hand in hand with Texas's push as a business hub and business friendly, both for Texas formed entities and for entities formed in other states. So like you said, you've got an Idaho entity or you've got an international entity formed under Spanish law, but you decide to opt into Texas's codified business judgment rule to obtain those protections and have some additional certainty about the standards that are going to be applied to your directors and your officers in their actions. And when you couple that with some of the forum selection provisions that have already been enacted through House Bill 19, creating the Texas Business Court, you have a situation where these entities are going to be able to really be certain about what standards are going to be governing their actions as opposed to maybe being analyzed on a piece-by-piece basis in these other states. I think the next aspect we're going to talk about, Kate, is another one that has some common law history, but is now being included and codified into the Texas Business Organizations Code. Talk to us about SB 29's elimination or modification of fiduciary duties, Kate.
Sure. So SB 29 allows specifically in the statute that limited liability companies and limited partnerships can waive fiduciary duties. Now, again, not a new concept in Texas. There's case law that's developed analyzing the validity and the application of fiduciary duty waivers or modifications of fiduciary duties in the Texas courts. But that has developed piece by piece as well. And so now we have statutory authority for limited liability companies and limited partnerships to waive fiduciary duties in their governing documents. Now, SB 29 does not change the existing case law for Texas corporations. Texas corporations cannot waive fiduciary duties in their governing documents. So that law remains the same. Now, SB 29 also creates and addresses some other protections that resolve or relate to issues that commonly arise in shareholder disputes related to forum selection provisions, jury waivers, and books and records requests. Why don't we start with forum selection provisions, Rafe? What does SB 29 say about that?
Sure. Senate Bill 29 allows a Texas entity to mandate in its governing documents that Texas is the exclusive forum and venue for an internal affairs claim. It adds certainty to questions about where and who are going to be deciding issues like questions relating to fiduciary duties and other corporate governance issues that come up, especially given the ability for a lot of these entities to opt into jurisdiction in the Texas Business Court, adding even more certainty both to where your matter is going to be decided and to who is going to decide your matter. And when you talk about who is going to decide your matter, Kate, you mentioned jury trial waivers. How do jury trial waivers fit in?
So SB 29 provides that entities can waive the right to a jury trial for an internal affairs claim. That waiver has to be knowing and informed. And SB 29 specifically defines when a waiver is knowing and informed. And that is when a person votes for or affirmatively ratifies the governing document, acquires equity shares of the entity when a waiver existed in the governing document, or otherwise knowingly or informatively consents or acquiesces to a jury waiver. Now, the last one I think we mentioned, Rafe, is the books and records request. What's going on there?
Sure. So anyone who's been involved in a discovery dispute or a books and records request knows that digging into electronic discovery can often be a time-consuming and expensive endeavor. SB 29 modifies some traditional shareholder, member, and partner rights to inspect company records, to streamline that process and prevent companies really from being held hostage by overbroad records requests. What does that mean? It means that SB 29 excludes from a books and records request electronic communications like emails, text messages, and social media messages unless those messages themselves effectuate an action taken by the entity. So if your board of directors is on a text chain and they all approve a transaction on the text chain, that would be subject to a books and records request. But otherwise, text messages, emails, social media messages aren't subject to a books and records request. SB 29 also goes further for publicly traded companies and partnerships. It actually prohibits book and records request if the entity that receives the books and records request reasonably determines the demand is in connection with a pending or threatened litigation. Basically, SB 29 divorces a lawsuit's discovery process from a book and record request. A party can't circumvent the discovery they're entitled to in a lawsuit by sending a duplicative or similar books and records request. Kate, you teased this at the beginning, but let's talk about the safe harbor mechanisms in SB 29, because I really think that they're the most innovative and interesting aspect of this bill.
Sure, and let's start with what the bill does with respect to conflicted transactions. So the bill has a procedure that seeks to provide clarity for entities considering entering into a large transaction or in which one of their directors or officers may be involved in a large transaction. And that process tries to provide those entities and directors and officers with clarity as to whether the transaction is potentially conflicted before the transaction is actually consummated, instead of waiting until after the transaction has occurred and seeing if somebody complains and argues that the transaction is conflicted. Now, SB 29 also provides, and this is important here, that those transactions are judged with the business judgment rule instead of the more stringent entire fairness standard. Now, practically, how does this work? There are a couple of options that are provided in the statute. And the first one is it allows the entity to, in advance of a particular transaction, our board of directors can form a committee of disinterested and independent directors to review the transaction on the front end and make a determination there. Rafe, what other options are provided in the statute?
Sure. So in addition to forming that separate board group, SB 29 provides an avenue for a corporation or a legal entity to actually go to the court and ask for a pre-closing determination about whether a given transaction is conflicted or whether this group of board members can really be considered disinterested. The process is that legal notice is given, legal counsel is designated to act for the corporation, and then the trial court holds a expedited evidentiary hearing to determine whether a transaction is conflicted or whether those directors are independent. It's effectively an upfront declaratory judgment action where a court is going to weigh in and bless a transaction or a director's independence before the closing of a deal. Kate, I know you and I have talked about this. Do you have any idea where this concept came from?
Got a bit of a hunch, Rafe. SB 29's unique approach here is in many ways analogous to Section 144 of the Delaware General Corporate Law, which is often referred to as Delaware's safe harbor provision. And under that Delaware statute, an interested transaction can be voided if it is approved by a majority of disinterested directors or disinterested shareholders. And at that point, the transaction is reviewed under the business judgment rule. Now, the party challenging the transaction can rebut the business judgment rule, and then the Chancery Court reviews the transaction under that more stringent entire fairness standard.
And Kate, I think your hunch is right. SB 29 does operate similarly, but SB 29 would go further. It bars a shareholder from bringing suit against the corporation unless the shareholder can affirmatively rebut the presumptions established by the business judgment rule. And that's despite there being proof that a director or an officer was maybe interested or voted for a transaction or authorized the transaction. So at first blush, Senate Bill 29 may even provide more protection for a corporation's directors and officers than Delaware's safe harbor provision. Kate, are there any other corporate protections that our listeners should know about?
There are, Rafe, and this next one is another really interesting one. Senate Bill 29 allows a publicly traded corporation to restrict who has the right to bring a derivative suit. And that restriction can be based on how much stock the potential derivative plaintiff owns. And the limit has to be in the corporation's formation documents or bylaws. Now, SB 29 says that limit can't be higher than 3%, but for a large publicly traded corporation, that can really affect who the potential plaintiffs could be in a derivative suit involving that corporation.
Thanks, Kate. SB 29's passage into law provides further evidence of Texas's push to be America's next hub for big business. When coupled with the development of the business court, it really shows that Texas is ready to be the place for large, complex disputes in the business court, but also with SB 29, that Texas is ready for large, complex commercial transactions as well.
And Norton Rose Fulbright's Texas Business Insider will be monitoring the rollout of SB 29 and all of the concepts that we've talked about today. Thank you for joining, and we'll see you next time.